Welcome everybody. Welcome to this session about understanding your governing document. This session is from Getting on Board as part of our Trustee Learning Programme, and we're really pleased today to have Gareth Roy from Russell-Cooke, who's an expert in this and who's going to be talking to us about that. The format of the session is that Gareth's going to talk for about 40 minutes, and then we've got a Q&A section. Please feel free to put your questions into the chat as we go. You don't need to wait until the Q&A section. We're then lucky enough that during Q&A we've got Joe Maguire from the Charity Commission for England and Wales joining us as well. So really pleased that we've got lots of expertise on this topic. And of course most trustees have never even seen their charity's governing document, let alone be able to interpret it. So this feels like a really important session. Just a note on England, Wales, Scotland and Northern Ireland. So the majority of this content is applicable for everywhere, for Northern Ireland, Scotland, England and Wales. The exception to that is when Gareth talks about anything related to the Charity Commission for England and Wales or the Charities Act 2011, where you'd need to check local differences. And obviously, if Jo is answering questions in the Q&A, she's from the Charity Commission for England and Wales. So a few bits of housekeeping from me before I pass over to Gareth. The session you will have seen is being recorded. You will get access to Gareth's slides and to the recording via a Zoom link after the session. That recording will include the chat. So if you want to ask any questions anonymously rather than that will appear on the recording, please feel free to send me a direct message through Zoom. The recording will also go onto YouTube. That version won't have the chat in it. You've been muted as you arrive. Please stay on mute unless we call to you to ask a question. That's just so that everybody can hear clearly. Closed captions have been enabled at our end, so if you want subtitles, you need to press the CC or closed captions button at your end. Please feel absolutely free to use the chat, to ask questions, to make comments, to share experiences. And then finally, a huge thank you to Russell-Cooke solicitors. They are sponsoring this session and a whole strand of our Trustee Learning Programme, which means that this session comes to you free of charge, which is really important to getting on board as a charity in terms of making Trustee Learning accessible. And of course, they've lent us Gareth for today, who has prepared this session and is coming along to share his expertise, and we're very grateful. So Gareth, I'm going to pass over to you.
Great, thank you, Penny. Delighted to be here and hopefully help some trustees understand their governing document. So hopefully you can see my screen. Penny, just checking that's all fine. Great. So as Penny mentioned, I'm from Russell-Cooke Solicitors, which is a large London law firm, and within the firm we have a team of lawyers who deal just with charities and not-for-profit organisations. So I work within that team and, amongst other things, advise charities on the terms of their governing documents and amending those governing documents. So session is on understanding your charities governing document. So during the 40-minute presentation section of the session, I'll cover what it means to actually talk about a charity's governing document, what it is, and some of the different terminology you find. I'll cover the fact that there are different types of governing document for different types of charity, because the sector, of course, is very broad and diverse, and there are lots of different types of charities and therefore different types of governing document. And then most of the session will be taken up by me running through some of the core key provisions in your charity's governing document and what they mean. And then towards the end, I will do a short section on how you might be able to check whether your charity's governing document is fit for purpose, and if you do want to make some changes and updates, how you would go about doing that. So first of all, what is a charity's governing document and why does it matter? So some of you might not be familiar with the term governing document. Different charities use different terminology to talk about their governing document, which depends on their legal structure and other factors. So you might have heard constitution or trust deed or articles of association, and all of those terms just mean the charity's governing document. The the use of the term governing document is an umbrella, if you like, for all of those variations. And what it means is it's the rule book of the charity. It's the most fundamental document to the charity, setting out why that charity exists and how it works, who has what rights, who can make what decisions. So the most fundamental document from a constitutional standpoint. So important to know what it says, because otherwise, how do you know what the organisation is for, and who can make decisions, and who has the right to do what? Also important to know what it is from a personal perspective as a trustee, because you have your legal duties as charity trustees, and as the Charity Commission's CC3 guidance says, the Charity Commission expects and wants trustees to know what their governing document says and to comply with what's written in that governing document. So from a personal perspective, also important to know so you can fulfill your duties. And finally, I've just put a bullet point on this slide that very briefly just says disputes. The reason I've put that on there is because some of the charity disputes that we end up advising on, I think a great deal of them would either not happen at all or would be curtailed if sometimes provisions in the governing document were a little clearer, or perhaps were a little better understood by the trustees of the charity. So understanding and knowing what's in your governing document and sticking to it is a good way to hopefully avoid those disputes. I mentioned a lot of different terminology in this area. And one of the main reason for that is the fact that charity is a legal status and it's not a legal structure. Now, that sounds quite technical, and it's sometimes quite difficult to explain exactly what I mean when I say that. But one way I always try and explain it, in the hope that it will help, is that charity as a status is a label that you can stick on different types of organisation. So charity is a special tax status, and there are different types of charity, different types of legal structure, and they have different types of governing document. So on this slide, the four main legal structures that charities can take are set out. There are other legal structures, such as royal charter bodies, for example, but I don't propose to cover those today. And next to the legal structure is the term that's most commonly used to refer to that charity's governing document. So for an unincorporated association, it's the constitution. For a trust, it's normally a trust deed, or it might be a deed of settlement, or it could be just some terms in someone's will. If your charity is a company, the governing document is referred to as the Articles of Association. And if you're a CIO, a charitable incorporated organisation, the governing document is referred to as the Constitution. So moving on to the main section in terms of what I'll be covering, key provisions in your charity's governing document. So I'll go through most of the bullet points on this slide and talk about what's in there. As I mentioned, obviously, there are a lot of charities, I think around 170,000 registered charities. So a really wide range of diverse and interesting organisations with a wide range of histories, legal structures and governance models. Therefore, they have some very different looking governing documents. But the aim of this session is to talk through the core provisions that we'd expect to see in most or nearly all of those charities' governing documents. But just a note on the diversity that you find. The first provision I want to talk about, I think, is the most important provision in your charity's governing document, which is the objects clause. So this is the charity's reason to exist, its purpose for being. I think if there's one provision in your constitution to try and ensure that you are familiar with and you know what it says, it is your charity's objects clause. Everything a charity does must further its objects, And ultimately, all of the decisions the trustees make should be made with this in mind. It should be at the very top level of your strategy and your aims. There are, of course, a wide range of charitable purposes that might be covered depending on what your charity does. So, for example, the advancement of health, the advancement of education, the relief of poverty, etc. From a legal perspective, the clause in your constitution has to be drafted in a way that's acceptable under charity law. So the objects have to be exclusively charitable. You can't have mainly charitable objects and something else tagged on. They must be just charitable. And that is something that the Charity Commission obviously understandably looks at closely if you were trying to register a new charity. And then in terms of analysing and reviewing those provisions, once you know what they are in your governing document, it's important to be aware that charities evolve and their activities evolve and new opportunities arise, and there might be some mission creep over time. So from time to time, you might need to review and update those objects. For example, if you're a local community organisation with a geographical restriction and you were set up to operate in 1 or 2 London boroughs, just by way of example, and you've grown and you're now looking to do things further afield, you will need to revisit that clause and seek the Charity Commission's consent to expand that geography so that you can do things further afield. Or another example that I came across recently with one of our clients, they were set up to carry out medical research in relation to a particular condition, but in the course of actually carrying out that research, they found things that were relevant to other medical conditions, and they wanted to therefore carry out further work to be able to use that information usefully for other people with other conditions. So another good reason for them to broaden their objects. It's very likely that you'll need Charity Commission consent to update your objects, so you'll need to get that first before you do it. And I should mention that the worst case scenario that fortunately very rarely comes to pass, but if as a trustee you use the charity's money to do things which are outside the objects and therefore are legally outside of the powers of that charity, in a worst case scenario, that could be considered a breach of trust, and you could have to repay that money to the charity so that it can be used for the purposes that it was supposed to be used for. Now, as I say, it's very rare that that happens, and generally if you've acted in good faith as a trustee, it's unlikely for that to happen, but I think it's useful to be aware of the risk and therefore the importance of ensuring your objects are still fit for purpose. So the next set of provisions I want to cover are trustee benefit clauses. So provisions in your charity's governing document that set out whether and to what extent a trustee can receive a benefit from the charity in some form or another. Now, the default position in the sector is that trustees are volunteers and generally aren't expected to receive any substantial benefits from the charity that they are managing. There are exceptions to this, and different governing documents in the very diverse sector we've talked about say different things about this. 3 provisions that I think trustees will always, or very nearly always, want to see in their governing documents in relation to benefits are provisions clarifying that trustees can claim expenses and that trustees can be protected by indemnity insurance and an indemnity provision from the charity saying that if, for example, a third party tried to sue a volunteer trustee for something they have done in their capacity as a trustee of that charity, the charity will foot the bill. Within certain limits, of course, not if that trustee has acted fraudulently or something like that. On the expenses point, I think expenses aren't always claimed by trustees, particularly if a trustee feels that they don't need to do so. But I think it is good practice to make it clear that expenses can be claimed and to have a clear policy in that regard, so that you don't accidentally deter certain people from becoming trustees, and potentially affect the diversity on your board. For example, younger people might be more concerned about having the train fare of getting to the board meeting met. That's my thought on expenses. Payment for being a trustee is very rare, and certainly in small charities isn't something we would expect to see. Payments for things that come outside of your trustee role, so something additional services or goods you might supply to the charity, are sometimes permitted. But important to understand what your governing document says on that. Some charity governing documents contain an absolute prohibition on that, in which case you cannot do that. Some are silent on it, in which case you can use provisions in the Charities Act 2011 relating to England and Wales if you want to pay a trustee for services or goods, and there are several conditions to meet, as you would expect if you are going to do that. And sometimes it says very clearly in the governing document what you need to do if you are going to, for example, pay a trustee for services. And one of the key things I think to remember if you are ever looking to do that is to manage your conflicts of interest properly. So clearly the trustee who might be paid for doing something shouldn't be in the room deciding whether they are going to be paid and on what terms. They shouldn't be there for that. And there are other provisions that are often set out in governing documents that cover slightly less common situations. For example, if a trustee loans some money to the charity, can they be paid interest and within what limits? And often there's a catch-all provision saying that trustees can receive other benefits, provided that the Charity Commission or the court authorises that first. So that's trustee benefit provisions. The next section I want to talk about is membership in charities. So before I talk about the provisions in the governing document that you might find, I think first of all it's really important to understand if you have members or if you don't. If you have the legal form of a trust, you do not have members, you just have trustees. If you're a company, a CIO, or an unincorporated association, you do have members, and those members are the people who have ultimate constitutional control over the charity, generally with the right to appoint and remove trustees and to change the constitution. So the question that follows on from that is, who are those members? And being able to answer that question is very important. And they may just be your trustees, in which case, ideally, you have a very clear provision in your governing document that says that. So it's beyond doubt that the trustees are the only members. And occasionally those trustees then have to make a decision with their members' hat on, for example, if you're amending the constitution. But that's all fairly straightforward. Alternatively, if you have a wider membership, so not just the trustees, for example, it's a common structure if you're a small charity in your community centre, generally intended to be set up as a bit of a democracy within the community. You'll have an AGM and the wider membership will come together, have their say on the charity and appoint trustees. Then you will have some more detailed provisions in your governing document in terms of members being admitted, or removed, how members' meetings must be held, how much notice do you need to give, can you send notice by email, what's the quorum for members' meetings, how many of your members need to be there to make a valid decision, etc. And one provision that's sometimes missing is in relation to the use of technology. So lots of charities now want to be able to hold virtual or hybrid meetings, but sometimes the governing document hasn't quite caught up with that and doesn't anticipate that. So that's something to check if you do want to hold virtual meetings, and if necessary, to update your provisions around that. The other bullet point that I've put on there is in relation to written resolutions. So the members normally will be able to pass resolutions in writing outside of a meeting as well. And your governing document may have some provisions that explain how that can happen. Clearly, if you have a very large membership, it won't be practical to send everyone a document and ask them to sign it and send it back. But if you have a smaller membership, that might be something you want to do. And having covered members, the next couple of slides are on trustees and the provisions you'll find in there in relation to trustees and their management of the charity. So the trustees are the people who are responsible for the strategy and management of the charity, and I suspect most people on this meeting are trustees or perhaps are about to become trustees of a charity. So in terms of the composition of the board and numbers on the board, you'll often have provisions in the governing document that say it needs to be between X and Y. Not always, but often. The Charity Commission, generally speaking, wants charities to have at least 3 trustees. The Charity Governance Code recommends a board of between 5 and 12, generally speaking. But as we've noted, it's a diverse sector. There's no right answer. It will depend on your organisation, what's right for you. And normally we find in smaller community organisations a slightly smaller board. Terms of office for trustees, again, it can vary. For example, amateur sports clubs often have 1-year terms of office and everything refreshes at the AGM. But we tend to find that 3 years is fairly typical for most charities as a term of office as a trustee. And then at the end of that 3-year term, of course, if someone wants to stay on and the board thinks that they should stay on, then that term can generally be renewed. But make sure you do remember to renew that term of office. Your governing document will probably say that that needs to happen via a positive resolution. So if you haven't done that, there's then a slight grey area as to whether that person is validly still a trustee or not. So do set some reminders in your calendar to renew terms at the relevant point in the year. In terms of the total number of years that a trustee serves on the board, there's always a question about whether to cap that length of service or not. So again, a fairly typical provision that you might find in some charity governing documents is there's a cap set at 3 times 3 terms, so 9 years in total. And the Charity Governance Code recommends that if possible, trustees don't serve for more than 9 years, except in exceptional circumstances. The idea being that refreshing the board over time is good governance. So you will find in some charity governing documents a provision that says you cannot serve after this point. So if you have that in your governing document, you need to abide by it. In practice, I think we find that most small charities are reluctant to write that in to their governing document as a black and white always requirement. And while they may have that as an aspiration, it won't necessarily be written into the governing document because of potential concerns about finding enough volunteer replacements when that time comes. There'll also, of course, be provisions in there setting out how the trustees are appointed, and very important that you know what they say and that you go through the correct process to do that. For example, is it a board resolution? So is it just the trustees that decide at their meeting and they pass a resolution to appoint a new person? Or is it an election that takes place via your wider membership? Or is it a bit of both, in which case there might be some numbers setting out how many can be appointed by the board and how many can be elected by the members. And sometimes if you have a wider membership, there'll be a more detailed formal process, for example, in terms of going to the membership for nominations in advance before the notice is then sent out for the meeting, before the election then happens at the meeting. In terms of removal of trustees, there should be a provision in your constitution that sets out when that will happen. So generally, standard things we'd expect in there would be a trustee can resign. Often there's a provision if a trustee loses capacity that the other trustees can note that and remove them from the board. And perhaps slightly unnecessarily, it often says if a trustee dies, they cease to be a trustee. There are other provisions that you will then find in some governing documents and not in others. For example, if a trustee doesn't attend 3 meetings in a row without any good reason, they can be removed by the board because they don't seem to be engaged. Sometimes there will be a provision or even a legal right, depending on your legal structure, for the members of the charity to remove a trustee. And sometimes there might just be a general power for the board as a whole to remove a trustee if they believe it's in the best interests of the charity to do so. And I think we generally recommend that that power is included, but with some safeguards to ensure enough people are at the meeting and it's, carefully thought about. The individual who's potentially being removed has the opportunity to come and defend themselves, etc. But we have had situations where that power isn't in the governing document and a trustee really should leave, but they refuse to resign, and it creates a bit of a difficult situation. And we've covered the composition of the board, how the people on the board, trustees, make their decisions. Again, there will be several provisions in your constitution that set this out, and clearly important to know what they say, so you know how you can make your decisions and where the limits of your authority lie. Sometimes there'll be a provision that says there's a minimum number of meetings per year that the trustees need to hold. Often 4 is a kind of common number that's in there, or the governing document may be silent on this and it's up to the trustees to determine that. How can you actually hold meetings? I think we would nearly always expect to see a provision that allows the trustees to be able to meet virtually or by telephone now, although some charities still prefer in-person meetings, and they might have a provision that only allows virtual meetings in exceptional circumstances. I have seen that. Who can call a meeting? There should be a provision in your constitution saying who has the right to actually call a trustee meeting. It might say it's the chair or 3 trustees acting together, so the authority of the chair isn't undermined, or it might say that any trustee has the right to do that. There'll then be provisions setting out how your meetings will work, so how many people need to be there, what's the quorum in order for you to pass valid decisions. Clearly you need to make sure that that's met at each of your meetings. How do you vote? Generally, it will be a majority decision. Often the chair will have a casting vote if the votes are split. And then an interesting one in terms of written resolutions, so making decisions outside of a meeting. Although we say written, generally that will include email and other electronic communications as well. Some charity governing documents will say that those decisions need to be unanimous still. The idea behind that being that if you haven't had the opportunity to discuss and debate at a meeting, everyone should be very sure about it. But it's much more common, I think, now to find majority or 2/3 as a sufficient number to make decisions outside of a meeting. And then in relation to the use of committees and delegating authority, again, you may have specific provisions in your governing document that say if you're going to form a subcommittee, there are some restrictions on that. For example, 1 or 2 trustees need to be on every committee. So if you do have that, again, knowing what it says and then abiding by that when you set out your terms of reference for your subcommittee is important. Next slide, again on trustee decision making, is I thought it was worth separating out specifically the need to manage conflicts of interest properly. So an important provision or process to understand if you're going to ensure good governance. It's also something that the Charity Commission will generally get quite concerned about if it's not properly addressed. So classic example was the one we talked about earlier. So if you as a trustee or someone related to you is potentially going to get a benefit from the charity, let's say a payment for services, you should declare that that is a clear conflict of interest. You should withdraw from the meeting and you shouldn't be present for any decision that's made in that regard. And whenever you are going through the process to manage conflicts, you need to follow what your governing document says on that. So it might be that you have a fairly short and simple provision, as CIOs often have, simply saying that the conflict should be declared, the individual should leave the room and not take part in the decision making, and you should then record that in your board minute. Or you might have a slightly more detailed provision in your governing document. Often, if you're a company, you'll have a slightly more detailed provision, perhaps allowing more minor conflicts of loyalty to be authorised by the board, and for the board to determine that's not material enough to require the individual to leave, they can stay and provide information. I think what I would say is, first ensure that you actually have this provision in your governing document, because it's sometimes missing. And then if you do need to manage a conflict at any point, ensure you follow what's in the governing document, and also if you have your own policy on it as a charity, follow that, and have a look at the Charity Commission's guidance on managing conflicts of interest as well. Right at the bottom, nearly always at the bottom anyway, of the charity's governing document, you will find a clause setting out how the charity can be dissolved. Might be for a variety of reasons that your charity is considering dissolving, ceasing to operate. It could be because financially you can't keep going anymore and it's a sensible decision for the trustees. Or at the other end, it could be the ultimate pat on the back. Your charity has done everything it can to further its objects and it's no longer needed, which is pretty rare, but not impossible. Your governing document should have a provision that sets out the process that you need to follow if you're going to make this clearly very important decision. So it will say who has the right to make that decision. For example, is it the trustees, or if you have a wider membership, is it the members? There may be a fairly high bar, such as 75% plus, to go ahead with this, or it can be different in different governing documents. There may also be some specifics set out or some specific restrictions on where your assets can go. So clearly, as a charity, any remaining funds that you have when you close down must be used for your charitable purposes. Normally, you'll ensure that by transferring those funds to another charity with similar objects. Some charities have more specific provisions in their governing document, for example, saying specifically that the funds must go to a particular charity, or slightly more specifically than just saying they need to be used for the purposes, they must go to a charity with some specific restrictions in their governing document. So if you are ever going through that process, just find that clause in your constitution and obviously meet what it says. Or if you need to update it, then it's one that you would go to the Charity Commission for consent to update in nearly all cases. So having covered some of those core provisions and what's set out in them, I'll now just briefly talk about how you might check whether your governing document is fit for purpose, and then if you decide it needs updating, how you might go about updating it. So one, fairly rough and ready, but fairly easy way to approach this is to look and see when your governing document was last updated. If it hasn't been updated since 1970, it probably needs revisiting and bringing up to date. If it was last updated 2 years ago, maybe it doesn't. I think it's worth looking at the objects clause as the most important clause in the Constitution and checking, does this still match what we believe our purpose to be and the activities that our charity carries out? And if it doesn't, should we consider updating it? Sometimes it can just be a terminology update as well. It won't necessarily be in relation to the substance of what you do, but it might be sensible to change terminology that's become outdated and doesn't fit with how you describe yourselves anymore. I think it's also worth looking at the governance structure. So in terms of who your trustees and members are and how you make decisions, it's worth checking what your constitution says about that and whether that matches how you operate or want to operate in practice. So a fairly common example we come across in that regard is when charities have been set up with the intention of having a wider membership, and maybe they did have a successful wider membership of engaged people for many years, but that isn't the case anymore, and at their AGMs it's mainly the trustees who come, and in those cases often the charity that we're advising updates their governing document to just say that the trustees are the only members and we won't necessarily have AGMs anymore. We will pass resolutions at trustee meetings. Clearly, that's a big decision. It needs to be thought about carefully, and you need to think about who those members are that you are removing from the decision-making process. But if they're not engaged in it anyway, it might be something to consider. It simplifies your constitution and your administration and probably lowers your costs in the long run as well. Conflicts of interest management I've put in there because I think it's something that I often see missing when a charity governing document hasn't been updated for a while. So check that that is in there. And also what you might do is just have a look at the Charity Commission's model governing documents. Open that on one side of your screen, open your charity's governing document on the other side and see, does this look about right or not? Just a note of caution when you're doing that is there are various model documents from the Charity Commission that differ depending on the legal structure of your charity, so you'll need to pick the right one to compare it against your own. And then finally, I'm conscious that I don't want to go too far over my 40 minutes. How do you change your charity's governing document if you decide that it does need updating? In terms of drafting the changes, if your charity is fortunate enough to have some budget, using advisors is helpful because it can be quite complicated. If you don't, using in-house expertise to the extent that you've got it, maybe you've had a trustee who's gone through this process with a few other charities before, is great. And the other thing that you can do is, again, consider using the Charity Commission's model documents that are available on their website, either starting from afresh and adopting their model document, albeit tailoring it for your charity, or perhaps just taking some clauses from it that you see are missing, such as a conflicts of interest management clause. You'll generally need Charity Commission consent to make any changes to your objects, clauses relating to trustee benefits, or the dissolution of the charity. So you'll need to get their consent to do that, and you can do that via the Commission's online forms. If you're an unincorporated charity, you'll also need the Commission's consent if you're looking to change any provisions relating to permanent endowment, which I won't explain what it means now, but if that rings a bell and you have it in your charity, you want to consider that. Or if your governing document has third-party rights, gives a third party, perhaps a founder, the right to do something and you want to change that. Then in terms of actually making the changes, let's assume you either don't need or you've already got charity commission consent. How do you actually pass the resolution to make those changes? Now, historically, it's been very different for different charities depending on their legal structure. However, very shortly, hopefully by the end of this year, although I'm not quite sure if it will be by the end of this year, provisions in the Charities Act 2022 will come into force that will make the process much more consistent for charities across the board, regardless of your legal structure. So without going into the detail of all the potential ways to pass those resolutions for each legal structure, generally speaking, 75% plus voting in favour at a quorum meeting of your members will be enough to make the change, unless you're a trust, in which case you don't have members and it's 75% plus of the trustees. And then final note was just on filing. Do remember, once you have passed that resolution, to file that resolution and the new copy of your new governing document with the Charity Commission, because it does sometimes get forgotten. And if you are a company, you'll also need to file it with Companies House. I'm only slightly over my 40 minutes, so I'm quite pleased with that. That's the presentation part, and so I'll pass back to Penny to field some questions, if that's okay.
Thank you, Gareth. That was utterly fascinating. Brilliant. Thank you. We've got loads of questions. Some of them are in the chat. Some have come to me directly. So just to say to everybody about how we're going to kind of handle those questions, I'm going to try and pick the ones that I think are of the most relevance to the greatest number of organisations that are likely to be represented here. So many apologies if we don't get to your question. And Gareth and Joe will say if it's slightly out of scope, if it's too specific, if they'd rather take it offline and so on. So they'll say if they can't ask a question, because obviously I haven't checked with them in advance. Gareth, if you wouldn't mind stopping sharing so that we can see you big, that would be brilliant. So the first question is from Martin, which I think is a great one. How do you determine the line of whether something represents creep from your objects or not? How much discretion is there? And should we throw that one to Joe first, being as Joe's sitting listening?
Okay, but I mean, basically, if you can't fit your activities to what your objects say, if you're struggling to think, oh, how can I shoehorn this into what the object says, then you've probably drifted from your objects. I think it's kind of a bit of a common sense in the first instance. If you're struggling to think about how you might shoehorn it in, you've probably gone too far.
Okay, that's helpful. That sounds like some sense about this. Yes. Anything to add to that, Gareth, or do you want me to whiz on to the next question?
No, I think I'd agree with that. Please whiz on.
Okay, whizzing on. Samantha says, who is responsible for updating the governing document?
The trustees, really. I mean, so in terms of who has the right to update the governing document, if it might be the members, depending on your legal structure and whether you have a wider membership. But in terms of making sure that that document is fit for purpose and up to date, that would be the trustees.
And I don't know if, and Samantha, come back to us in the chat if this was the case. Presumably charities with staff might have staff doing some of the legwork in terms of researching which bits might need to be updated in the regular wording, but it always comes back to the trustees or members. Yeah, okay.
Yeah.
A question from Shelley, and tell us if this is out of scope. And Shelley works for a local infrastructure organisation, which is why she's asking this question. But she says, what are the names of governing documents for community interest companies and other sorts of enterprise organisations? Gareth, I'll come to you on that one.
So a community interest company isn't a charity. It's a slightly different thing, but it's a company. So its governing document is its articles of association. Then in terms of other enterprises, I suppose that could mean a range of things. Typically, when people talk about social enterprise, it's a not-for-profit company with a set of articles of association as its governing document, but it could be something else. Yeah.
So it depends. Okay, thank you. A question from Angela about honorary officer roles, i.e. chairs, treasurers and so on. Do they need to be reappointed annually?
No, depends what the governing document says again. So sometimes governing documents will be specific in terms of what the officer roles are, chair, treasurer, secretary, etc., and how those people are appointed. Sometimes it will be much more general, and it will say the board can appoint the chair and such other officers as they want from time to time. But it's really just understanding what your own governing document says. Is it the trustees that make that decision? Is it the members? How long is the term, etc.? Should be set out.
Great. Joe, anything to add to that one?
No, I'd agree. Check your governing document.
Okay, thank you. A really good question from Jim, and we had this issue at Getting On Board the charity, we had this issue. If your articles are written in male pronouns, should they be updated, or is that just how legal documents are drafted? Joe, I'll come to you on that one first.
You don't have to update them. It's up to you. We wouldn't consider that to be a substantive change, though, if you're just updating pronouns to get it. They were drafted very, very old school. So, yeah, it's entirely up to you, really.
Thank you. And Gareth, is it still current practice to no, okay.
Yeah, I mean, you will obviously you'll see that in older documents, but certainly if something's being drafted now, certainly if we were drafting something now, it would be gender neutral terms.
Thank you. A question from Shelley about ex officio trustees, and I wonder if the question's quite broad, but actually I wonder if first of all you could explain what ex officio trustees are, Gareth, and then talk about how to kind of handle them in some of what you've spoken about.
Yeah, so they're people who are appointed to the board by virtue of a position that they hold somewhere else, typically. What's the question?
She just says, could you also cover if you have an ex officio trustee? So I guess are they treated any different once they've been appointed?
No, so in terms of their duties and how the board operates, they have the same legal duties as a trustee. The governing document may, of course, I mean, it almost certainly does set out specific provisions about their role, how they're appointed, what the position is, how long their term is, and slightly different rules might apply, for example, in relation to their removal. But the core of how the board operates and what that trustee's duties cover is the same as for any trustee of the charity.
Thank you. Anything else to add about ex officio trustees, Joe?
No, I think I'd just agree that once you're appointed, from a commission point of view, we don't really mind how you get there. Once you're there, you've got the same duties and responsibilities as anybody else.
Brilliant, thank you. A question from Rona, excuse me, which I'm just trying to find. And it's about quorum. So she says, where the quorum is 4 and that is met, can the meeting make final decisions if the board is 10 or 11, i.e. it would be a minority decision? Joe, shall I come to you on that one?
It depends on the decision that you're making and what your governing document says about the majority needed to make a decision. So sometimes, as Gareth was talking about, the big decisions, in terms of making those, sometimes you need 75% of your members to be in attendance. So if you, regardless of whether you've met that quorum, if you haven't got enough people there, you may not be able to make that decision. So that would be my view.
Thank you. Anything else to add, Gareth?
Yeah, I think it's probably I think the fact that you're asking the question suggests that you might have a concern that 4 isn't enough people to really make some of the decisions that legally they may be able to make in relation to some things if the quorum in the governing document is only set at 4 and you have a board of 11. So it's just worth, I think, considering that as a board and whether you want to raise the bar if that is a concern. But there's always a bit of a balancing act to be had here, because you don't want to set it too high that then you struggle to get quorum meetings. So, yeah.
And I wonder if this question is connected to potentially why that question comes up sometimes. Somebody says, we don't have terms of office. What is the best way to introduce them. So I guess if you've got essentially sleeping trustees and people aren't moving on and they're not being refreshed, what's the best way of introducing terms of office, Gareth?
By updating your governing document and writing those in, which so you do find often it's older charities, most likely to be trusts, that you don't have terms of office written in, and sometimes it's a little bit of a difficult conversation to put those in. But in terms of doing that, perhaps one way is to look at the charity governance code and to point people towards that, and note that it does recommend terms of office and a positive decision to refresh, rather than someone just staying there forever without that taking place. But yeah, updating your governing document is the way to do it.
Brilliant. And Joe, anything else to add on terms of office? Presumably it's something the Commission recommends.
Yeah, it is something that we recommend. It, a bit like the governance code that Gareth referred to, we use that quite a lot in terms of good practice. So it may not be a legal requirement, but it is good practice, and it works better when you get that kind of refresh every so often. So yeah, definitely recommend it.
Thank you. A question from Jim about trustee benefits. Can trustees be eligible for any staff discounts or non-financial benefits that staff receive? Who would like to take that one?
I can take that one. Any benefits to trustees need to be authorised from somewhere. So there's no kind of default. So if you're getting a benefit, albeit that it's one that the staff get, it would need to be allowed for in the governing document. And that clause should cover any benefits, not just payments, but any other benefits. So, if it's staff discounts, we sometimes see free, newsletters, magazines, anything that's kind of a staff benefit or a member benefit. If the trustees get that, then it does need to be allowed for. Not normally a problem, but does need to be in there.
Thank you. Gareth?
Yeah, it'd be interesting to know the specifics on that one, I think, in terms of where is it a discount that staff get at third-party retailers or something that we're trying to address, and then see what the governing document says, as Joe says, in relation to anything that crosses over with that.
And would that make a difference if the benefit was coming from an external organisation rather than from the resources of the charity itself? Does that make a difference, or does that still have to be authorised somewhere?
I think it would still have to be authorised, but it's something that we take into account in making that decision to consent, if you know what I mean. If it's third party, right, that everybody's entitled to, and it's not coming out of charity funds, then that would be a factor we take into account. But it should be written into the governing document to specifically allow it.
Thank you. Fascinating.
Quite niche, that one, I think, though. So
maybe not, though. In fact, one
maybe,
of our
maybe
was just direct message me to say, "Oh, we should think about this."
So, I could have opened the floodgates on that one.
You might have done, yes. And so there's a comment and a question from Emma. So Emma said, just for awareness, the Charity Commission currently have a 15-week backlog for processing applications for consent. I'll ask you to say something about that in a minute, Joe. You might just have got a longer list after this session as well. And she says, I recently spoke to the Charity Commission about making an application for regulated alterations, and they stated that indemnity insurance was an administrative alteration which didn't need prior consent. But I think the presentation indicated that it was a trustee benefit which would need consent. So is indemnity insurance a benefit? Does it need consent?
It is a benefit, but because it's now introduced in law, we don't regard it as a regulated alteration, because the power to provide trustee indemnity insurance, and it's important to distinguish between the payment for trustee indemnity insurance and Gareth's point about wider indemnifying clauses. So if you're looking to pay for trustee indemnity insurance, that is now written into law. We don't regard it as a regulated alteration. If it's something wider than that, then it is still a regulated alteration.
Okay, thank you. Gareth?
Yeah, so I think that's a really good point that Joe makes, and it's important to understand the drafting of those provisions in your own governing document, particularly if you're amending them. And I think what I would say from a practical point of view is, if in-house, when you do that, you've got any uncertainty as to what you are trying to draft in would be regarded as administrative or not, although Joe might not thank me for saying it, it would be to go to the Charity Commission and at least make the ask. And the worst that they can do is say, you don't need our consent for that one. But if you have any uncertainty in that regard, then take the cautious route, I would say.
It is, in our experience as well, or certainly in my experience, it's rare that people are just doing that one little bit. When people approach us for regulated changes, it tends to be one of a number of changes that they want to make, so the distinction almost doesn't matter in practice. But yeah, always sort of think about it and err on the side of caution, because as Gareth said, the worst case scenario, we turn around and say, well, actually you don't need our consent, but you go ahead and do it. So. And
what are the most common reasons that charities are amending their governing documents, Joe, that you see?
So the most common amendments we see are objects changes, where charities do want to.
Just on a meeting, so I will
develop.
respond to your email.
Somebody's not muted. Right. Let me just find who that is. Yeah, no, it's fine. They've muted them.
Okay.
Oh no, hold on. Martin, I'm muting you. You're talking to the world. There we go.
It's all very interesting, I'm sure. But yeah, so the most common requests we get are for objects changes. Beyond that, it's kind of trustee benefit clauses and admin clauses, where it is just about bringing the charity up to date to reflect. So Gareth was talking about, our model governing documents, and often our models have clauses in there that maybe sort of 10, 20 years ago weren't standard. So, trustees doing the job that they absolutely should do and seeing if their charity governing document is fit for purpose, they say, well, actually, this is fairly standard now. And I think it's understanding that it may be standard now, but we do need to think about whether you've made a case for you to have it in your charity. Just because everybody has it now, you still need to think about whether it's right for you and your charity and your charity's history to make the right decision.
And now that we've lost the automatic permission to have online meetings that we had during the pandemic, have you seen the quantity of changes that you might have expected to governing documents allowing trustee meetings to be online?
It's one of the things that people are tending to put in fairly routinely now. So where people are making administrative changes, it's worth noting that we don't have eyes on necessarily all administrative changes. So when you apply to us to change your governing document, our systems often will route those through if they are a straightforward administrative amendment. We do sample some, so you will find yourself in the queue to be looked at for some of them. It's not an automatic thing, but yeah, it is one of those things that people want to bring it up to date, and that is absolutely fine.
Thank you. Right, we're pretty much at the end. I've got a very quick question from Michelle to fire at Gareth, which is, do we have to adopt the model articles, Companies House? Our trustees want to simplify the language length of the document. Can we do this?
So model articles, in terms of what you find at Companies House and what's referred to as model articles in company law, aren't charitable, but I suspect you might not mean those, and you might mean the Charity Commission's model articles of association for a charitable company. In which case the answer is no, you don't have to adopt those. Certainly not. There's lots of diversity in charity governing documents, as we mentioned. But you should, as Joe said, consider what's right for your charity, making sure you meet the legal requirements and the governance requirements for your charity.
It's also worth just pointing out for CIOs, if you're looking at CIOs and incorporation as an incorporated status, then you do need to follow the models or have a good reason not to, or we'll ask you about having a good reason not to. So that's why it's really clear to be sure which ones you're looking at and which structure you're using.
Thank you. I am good. Thank you. That was such an interesting session. I really loved it. I hope everybody else did, and it felt pitched just at the right level for us. I've just posted the evaluation form in the chat. Please let us know what you thought of this session. We source all of these sessions from what you as trustees tell us what you need. So this idea for this session came from you. In the form, there's a section which asks you what else you might find useful. I briefly shared the slide, but we're out of time. So just to let you know what else you can get from getting on board, this is part of a wider free learning program called the Trustee Learning Program. You'll get a link to that in a follow-up email with the recording and the slides. Please do check out what else we have. We've got free guides on becoming a trustee and how to recruit trustees and how to diversify charity boards. They're all on our website. And then a very final plug for our Festival of Trusteeship, which is coming up for Trustees Week at the week of the 6th of November. We've got all sorts of absolutely brilliant sessions coming up for Trustees Week. We welcome 2,500 people from all over the UK to that, and we'd really love to see you there. The whole stand for aspiring trustees is free. Other sessions are £5 a session or £25 for access to the 23 sessions during the week. So thank you so much, Joe and Gareth, for a really, really enlightening session. Thank you all for coming. Thank you for your fascinating questions, and I hope you have a lovely afternoon.
Thank you.
Thank you.